Jeremy Hogan revealed on April 14 XRP will collapse. XRP to $0.01. Attorney Jeremy Hogan shares his expectations for the Ripple SEC case, as Ripple defendants' responses are expected by April 8. Welcome to the Rich Club channel. If you liked this video, don't forget to like it and subscribe to the channel. Do you think the analysts are right about XRP? Write the answers in the comments. Giving away 500 XRP at the end of the week. One random subscriber will receive XRP coins. Take a look at the instructions in the comments section. All you need to do is write the word XRP, watch the video to the end, to like and subscribe. Earlier, Ripple defendants Brad Garlinghouse and Chris Larson filed a motion to extend the deadline to April 8, 2022, to file their responses to the SEC's first amended complaint. All of this was provided in text order. In previous updates provided by defense attorney James K. Fillon, the filing of the individual defendant's response remains an initiating event. He stated that when the response is filed before April 8, a 2-week countdown begins from the date of filing the response for voicing the SEC's position and the joint proposed timetable in the lawsuit. It is expected that within a week after the filing of the responses of individual defendants, the SEC will inform the court of its position regarding the need for any additional information. The parties, both the SEC and Ripple, were also instructed to meet and discuss a briefing schedule for motions for summary trial. The parties must submit a joint proposed schedule for court approval no later than 1 week after the SEC submission. In no case will the respondents miss the deadline for submitting responses. The delay may be in the form of the SEC's refusal to agree to a reasonable timeframe, and then the judge will have to set the deadlines herself. At the moment, it is expected that the SEC will not interfere and everything will go according to plan. There's no way the defendants will miss the deadline to file answers. The delay could be in the form of the SEC refusing to agree to reasonable timeframes, and then the judge would have to set the timeframes. At this point, I expect the SEC to play that game. Explaining the relevance of the date when the Ripple defendants will submit their responses, Hogan stated. Judge Netburn links the deadlines to how quickly Garlinghouse/Larson will submit their answers. The earlier they are submitted, the earlier the countdown of the weekly hours will begin. A briefing schedule will be determined for the final court decision, which has not been considered before. He also said, it is assumed that the parties will outline the deadlines for filing and finalizing reports on the court decision. After these summaries are submitted, a decision on the case can be made, theoretically, at any time. Justice of the Peace Sarah Netburn ordered the U.S. Securities and Exchange Commission to submit all proposed amendments for closed consideration. It is assumed that the SEC will file them before April 8. In her ruling of January 13, the judge determined that the privilege of deliberative process, DPP, does not apply to certain sets of notes, since collecting facts from third parties is not necessarily a privileged activity. None of the notes contain communication between the lawyer and the client, so they are not protected from production. However, the judge also allowed the SEC to edit parts of the notes that reflect employees' own discussions or messages. At the end of March, the SEC filed a motion specifically asking the judge to allow the editing of some recordings made during some meetings with third parties. One of the meetings was devoted to the regulatory status of Bitcoin with Stanford Law School professor Joseph Grunfest. The former Ronald Reagan-appointed SEC commissioner warned the regulator against taking enforcement action against Ripple, warning that it could hurt XRP holders. One of the meetings under consideration was also devoted to the legal status of initial coin offerings, which enjoyed great popularity in 2017 and collapsed massively the following year. Ripple stated that it does not dispute any of the proposed revisions, but reserves the right to comment. The handwritten notes will be reviewed by the judge privately behind closed doors, which means that the defendants or other parties will not be able to view the unedited documents. The latest updates on the court relate to the request of the CEC dated March 23, in which she demanded to edit some parts of handwritten notes between her employees and third parties, referring to the fact that most of the opinions contained in the documents are personal and should be protected by the privilege of the deliberative process, DPP. Given the history of the DPP debate throughout the trial, there are some expectations that the SEC will try to edit internal documents as much as possible, stating that this is confidential information, thus leaving Ripple with little maneuvering for active protection. Earlier this week, Ripple said it was relying on SEC submissions, and a court review to determine whether the redacted parts clearly reflect the author's own thinking or reflect discussions and communication between SEC staff during meetings. Since only the court and the SEC have seen the unedited documents, the defendants have asked the court to decide whether the redacted parts are indeed protected by the DPP. Now the Securities and Exchange Commission, SEC, has requested permission to correct a typo in the handwritten notes of the minutes of the meeting between its employee Valerie Szczepanik and the cryptocurrency research center CoinCenter. In a motion filed yesterday, the SEC noted that it wants to change the date of the meeting. #Xrp community #SECA versus #Ripple #XRP. The Securities and Exchange Commission has filed Valerie Szczepanik's amended application regarding a meeting she attended with CoinCenter. The original statement stated that the meeting took place on June 20, 2018, and the amended statement corrects the date to June 20, 2017. In the initial statement, the SEC mentioned that the meeting between Szczepanik and CoinCenter took place on June 20, 2018. However, the original date of the meeting was June 20, 2017. The documents describe the records of Ms. Szczepanik about an alleged meeting with the CoinCenter, a non-profit center for research and protection of the interests of cryptocurrencies, on June 20, 2018. The notifications are dated June 20, 2017, and the meeting took place on that day. It is worth noting that the SEC's amended statement was published after Judge Sarah Netburn ordered the agency to submit the proposed amendments by April 8, 2022, so that the judge would conduct an objective review of the documents. Recall that on March 23, 2022, the SEC demanded to edit some parts of handwritten notes between its employees and third parties, since most of the opinions contained in the documents are personal, not public instructions. The Securities and Exchange Commission wants to edit some minutes of meetings with agency employees, such as Valerie Szczepanik, Michael Seaman, and Jonathan Ingram. After the deadline for submitting a response had almost expired, Ripple announced late on the evening of April 4, 2022, that it would not challenge the SEC's proposed editing request at the moment, as it did not have substantial knowledge on the matter. The blockchain company said that the court is more aware to decide whether to protect the proposed SEC redactions using the privileges of the deliberative process, DPP. The live XRP price today is $0.88 with a 24-hour trading volume of $3,740,000,000. We update our XRP to USD price in real time. XRP is down 0.4% in the last 24 hours. Do you think XRP will be able to win the court and restore its former price? Write the answers in the comments. That's it for today. Thank you for watching this video to the end. If you liked it, then don't forget to like it and subscribe to the channel.